Welcome. This presentation is provided to you by the Association of Autonomous People for educational purposes. It is essential for your liberty and safety that you perform your due diligence prior to implementing any of the following information into your lives. The mission of the Association of Autonomous People is to provide education to our members in order to stimulate our minds, increase knowledge, and promote critical thinking, and thereby increase opportunities to live free and prosperous lives. The Prosperity Program was created and is administered by the Association of Autonomous People. In this presentation, you will learn about the benefits of membership, the importance of legal research, a common law right called adverse possession, and I will take you through research in order to focus on how to determine if a property is viable for adverse possession. Now, some of the benefits for membership include education for members on business structuring, administration and funding, rights, the effects of laws on rights, financial education and education on investing, adverse possession as a common law right as previously mentioned. Our members are presented with opportunities for investments in group scenarios as well as business opportunities. We also provide our members business coaching and life coaching from experts in group settings. Now this slide shows a few links that I use, and what's important about these links is I want to show you that it is important to use reputable sources for your information. There's a lot of information on the internet, and if you go to private sites that quote law, sometimes they embellish, sometimes they misquote, sometimes it's just misinformation. You can stymie all of that by bypassing those private sites and going to reputable sites such as Cornell Law, as the government site that provides access to United States codes. Again, you'll see, for example, here the last link, the fourth link, is a link to Washington State's official site for the revised codes of Washington. Now, if you're not in Washington and you want to find your official statutes, simply do an internet search, type in official statutes or laws of your state, and they should come up. Now, if you're looking for a law library, simply do a search again, law library local to your specific community. Again, it is very important that you use reputable sites or reputable resources for your information and research. Now, usually when I talk to people about adverse possession, it's a new realm for them. They haven't heard of it or don't know much about it. So they ask, well, what is adverse possession? Is it legal? And how can they adversely possess properties? Well, we're going to answer some of those questions, or answer those questions in this presentation. And in the next clip, though, what I'm going to do is show you an example of adverse possession that was presented on CNN of a man named Dicaprio, I believe, out of Oakland, California, who's been living in a property for 13 years. Sit back, take notes, and enjoy the clip.
Well, this kind of sounds a bit like an infomercial, but it ain't. Own a house without ever buying it. Especially when you're talking about one of the priciest real estate markets in the nation. Welcome to something called adverse possession. It is a legal concept with very deep roots in California, but one that you should know isn't for everyone. It has certainly worked for my next guest so far. Anyway, Stephen Dicaprio moved into this abandoned century-old duplex in Oakland 13 years ago, and literally, he has made it his own. It all comes down to paying taxes, because when he went in there, he started paying the taxes, and he did so for years. Stephen joins us live from San Francisco. I'm also joined again by our legal analyst and attorney, Lisa Bloom. Stephen, I want to begin with you, first of all. This is from the files of what? Are you kidding me? You were homeless, you trespassed, moved into that house, and then just started paying taxes, and after a certain number of years, that officially, legally, made that place yours? Do I have it right?
Ashley, well, first of all, thank you for having me. And that is correct. In California, adverse possession takes 5 years of possession and paying the taxes, and that's what I've done. So, but I could give you more of the background on that if you'd like.
Well, I suppose the background is this. A, did you know that? Was this a strategy? And if that part's correct, maybe it's legally okay, but isn't it kind of morally yucky?
Well, I guess well, first of all, I'll just let you know how this all began. Back in 1999, my band, Lesser of Two, was a punk hardcore band. We toured all over Europe, and in Europe, there's squats all over Europe. They have libraries, they have social centers, they have all kinds of activities, and it was really inspiring for me. And then I came back to the U.S., and I lost my job, lost my house, and I started squatting houses. That was based on what I'd seen in Europe. And I've been doing this for about 13 years. I've been involved in a dozen or more squats in the Bay Area. And we've established a nonprofit, Land Action, to take the strategies and tactics to help social justice organizers establish their own squats that have projects or housing. And this is something that's been going on for, historically for a long time. If you have abandoned properties and no one's claiming them, no one's using them, this is a way for people in a society to take back those properties and put them to beneficial use, and that's what we're doing here.
Okay, so beneficial use. I just got to interrupt you there, Stephen, only because I hear what you're saying, and I see that you are putting a positive spin on it, saying that this is something that's beneficial to the community, but I can't help going back to the idea that the owner of record on this house is the estate of someone named Henry Curry, who died in the early 80s, and I can't help coming back to that this is kind of just taking what isn't yours. How am I wrong?
Well, I think that in what you just said, this is a person, this property had sat abandoned even before that individual purchased it, and it had been abandoned for as long as 40 years by some accounts in the neighborhood. And so an individual purchased it, and that person died, and no one came forward and claimed the property. So something has to happen, and if there's no one to take responsibility for the property, then someone needs to step forward, and no one did. And so it's a particular type of situation that this is designed for. It's not just any vacant property. It's designed for properties that have been in a state of abandonment that's really, there's no other solution.
I want to bring Lisa Bloom into this because she is not only really smart and really funny, but she's also a Californian, so she knows a thing or two about California law. Is there a benefit to this adverse possession? I like this guy. I think he makes a good point. He knows his law, but I can't help thinking that he's just taken something that doesn't belong to him.
Let me explain. This is actually a well-settled legal principle going back hundreds of years. Adverse possession. Real estate is different. We want homeowners to maintain their properties and pay the taxes. And if somebody lives openly and notoriously, those are the legal words, on a property, as Stephen did, for 5 years in California, and the homeowner doesn't step forward to say, hey, wait a minute, somebody's on my property, we know they've really abandoned that property. And we want people to maintain properties and pay taxes on them. And that's the concept behind adverse possession. And Stephen, I got to tell you, you had me with the solar panels. Once I see that you installed those solar panels on the roof, you got my vote, friend.
All right, you too. Well, listen, Stephen, it's interesting. I think the story's fascinating. I like you and don't like you all at the same time, but I think you make a very good point.
I'm going to bring you around, Ashley.
And I do want you to keep
well,
up
Ashley,
with
I'm a better neighbor than an abandoned property, so.
That's right.
I'm a better neighbor than having an abandoned property, so.
It'll be interesting to see what comes out, because it's still not completely settled. I know you can't sell the home at this point or mortgage it, but yeah, interesting story nonetheless. Stephen Dicaprio, thank you. Lisa Bloom, both of you, thank you very much. Stay with me, everybody.
Okay, so as you saw, what he said is that adverse possession is for specific types of properties, and that is very important. Again, one of the things that we're going to reiterate throughout this presentation is that those properties must be abandoned. They cannot be merely vacant. Now, if you go to the site here at this link, you'll see an article about zombie properties. Zombie properties are defined as properties that were homeowners leave their properties, they may or may not be facing foreclosure, but in this case, let's just say they are facing foreclosure. They decide to leave the home, and the bank has decided, for whatever reason, it could be for faulty paperwork, it could be because the property's not worth them taking, and they don't think that they'll be able to make their money back. For whatever reason, they've decided not to take the property, and the property sits there and it becomes dilapidated. Now, in Washington, for example, there are laws in Washington that specifically are very specific on how lenders can foreclose on properties through non-judicial processes. Washington has a Deed of Trust Act, and in that Deed of Trust Act, it is implicit that the holder of the note also be the beneficiary of the deed of trust. And if you're not both, if you are not the beneficiary of the deed of trust and the holder of the note, then you don't have standing to foreclose, essentially. There's a couple of cases that I'm gonna show you real quick, just the titles too, so that you can get to them and research them on your own. And those are, again, two cases, one out of Washington State Supreme Court, and one is an appellate court decision that supplemented the Washington State Supreme Court. The Washington State Supreme Court case was Kristen Bain and Metropolitan Mortgage Group. And initially it was Kristen Bain and Kevin Selkowitz who joined her in a wrongful foreclosure suit against this group of people that include MERS, or this group of corporations, that included MERS. MERS is an acronym that stands for Mortgage Electronic Registration Systems. And it was a system that was created by the banks so that they could essentially record their transfers of documents, and they wouldn't have to go and record them in each county record. It was a little bit too expensive for them, for whatever reason they believed that, and so, or at least that's what they stated, and so that's where they created MERS. In Bain, or in Bain v. MERS, the courts answered two of the three questions. Technically, they answered one clearly. They conditionally answered another one, and another one they refused to answer. And one was, the first one they actually did answer was, is MERS a lawful beneficiary under Washington's Deed of Trust Act if it never held the promissory note? And the answer was no, it is not. The other one was, what's the effect of that response or that answer? They refused to answer that question. We'll get into that here in a second why. The third one was essentially, does the homeowner have a cause of action if this is the case? And it was conditional yes, that if they can show that they had committed violations under the Washington Deed of Trust Act, then yes, they would have a cause of action. The second case specified a little bit more than the Washington State Supreme Court did, in that it said that MERS could not assign a deed of trust that it did not have an interest in. In other words, let's just say if you have someone's car that's sitting outside your house and it's not yours, it's on the street, and somebody comes by and is interested in that car, you can't sell it to them. You cannot assign it to them because you don't have interest in the property or in that car, that vehicle. So it was the same premise. If MERS was not a lawful beneficiary, then they don't have any lawful interest that they can actually transfer to anyone else. And that's what was reiterated in Doug Walker v. Quality Loans. If you want these cases, simply do an internet search for them, or email me, contact me, and I will send you a copy of the opinions. Now, as we previously stated, it is very important that you establish that the property has actually been abandoned and not merely vacant. All right. It could be, vacant. It could be someone in a situation where they have a rental property and it's just been empty for several months, but not necessarily abandoned. That doesn't mean that they're never going to come back to the house, never going to put tenants back in it. It just means that it's vacant for right now. What's their intent with their property for the future? Now, if you go to RCW 613050, one of the things that you'll see there is how a homeowner can abandon their homestead if they don't file a document entitled Declaration of Non-Abandonment. So if they leave their home for longer than 6 months and they have not filed this, and there are other elements that meet the criteria of abandonment, then they can be deemed to have abandoned their property. Yes. Now, there's a court case here that I have before you that's Willard Brown and Wells Fargo. Now, Willard Brown and his wife were occupants of a house here in Washington. They received a notice to foreclose, and they decided they wanted to basically just give up and bounce. And so they left and moved, I believe, to Florida. When they moved to Florida, they established residency there. They changed their license, obtained a Florida license with the new address in Florida, and they also had left utilities that were unpaid and or had shut-off notices. There was a lien on the property, and essentially they had other elements that existed that showed that they actually had abandoned the property. For example, like I just said, they established a lease in another property in Florida. They changed their address on their for their driver's license, and they also left utilities unpaid, like they had no intention of coming back to pay it or deal with the property any longer. And so the courts deemed that they actually abandoned their property and essentially gave up their rights to any recourse they had to acquire any remaining balance that may have gone over and beyond what the deficit was for the bank. Now, there were junior liens on the house, so it wasn't like they just gave up the money to the bank. It's just they couldn't challenge whether those junior liens were valid and should have been paid. Now, in this case, it was an unpublished case. This is Thomas and Susan Arrington. And in the end, it was Susan Arrington who was sole occupier of the property because I believe they got divorced. But what happened is Susan committed embezzlement and confessed to it. And so the court said that she had voluntarily left the property when she was incarcerated for 6 or 7 months. And I know she was incarcerated for 7 months when Wells Fargo came and foreclosed upon her. And she attempted to challenge that she did not give up her claim or her right to her property and didn't want her junior liens to out her of her money as well. But the court said that, hey, you committed a voluntary act of embezzlement. You knew it was a crime. You did it anyway. You got incarcerated for that voluntary act. So therefore, you leaving your property was a voluntary act. You did not file a declaration of non-abandon before you were incarcerated. And so therefore, your property is deemed abandoned. Now, the link here at the bottom is the official site where you can go to research Washington cases, court cases, Supreme Court cases, and appellate court cases, and you can actually find this there. Again, this is an unpublished case, and all that means typically is that you can't cite it in order to control the court when you go in. So it's not a citable case, but it is something that you can research to understand the premise of abandonment. Now, as I previously said, you heard the attorney say, she said that adverse possession goes back hundreds of years. Actually, it goes back thousands of years. If you've ever read the codes of Hammurabi, you'll see that in those codes of more than 2,000 years old, that there was actually a term in there for adverse possession, that if a man had left his home and came back later on after, I believe, 3 years and someone else had taken it, essentially he wouldn't be able to get it back. So it is an old doctrine. It's an ancient doctrine. As you heard also, Stephen Dicaprio, when he was in Europe, he saw squat communities, not just squat properties, but squat communities where they actually, took abandoned properties and claimed them as their own or took control of them and upkept them and so forth. Now, the doctrine of adverse possession is a legal doctrine, and I wanted to show you this bit of information so that you could see why it was important or why adverse possession has been around so long. Essentially, it is instituted in order to establish that properties have their that we use maximum utilization of land and encourage the rejection of state claims and, most importantly, quieting titles. All right. Again, you have to look at the common law principle in that if someone abandons a piece of property, that means there is no injury, no owner to claim an injury if someone takes it or damages it. So if there's no injury, there's no one that's injured, then it means there can be no one that actually complains and states that, hey, you stole my property or you did this to my property. No, you actually abandoned it. And so as you saw before in those earlier court cases, that it is possible for you to abandon the real property, and they have done so. Now, I included some other cases in here that were beyond Washington, I believe Colorado and whatnot. What's interesting is Illinois has a very interesting perspective on adverse possession. They actually say, excuse me, have a program where they encourage people to come and take abandoned properties, renovate them, and make them available for low-income families. And if they do so, they'll actually expedite the process for them to be able to acquire that title into their own names or their corporate names. And so that's interesting. I think that's something that more states should actually look at, because one of the things that you're going to see is that we actually here in Washington do have, not necessarily a problem with, but we do have more abandoned properties than we like to admit. We probably don't have as many other states, especially like Michigan, because some of the things that Detroit's going through, Nevada and Arizona for some of the things that they went through with foreclosures and whatnot. But that's something that we'll deal with and we can talk about it another time. Now, there are 4 elements that must be met for judicial review to establish adverse possession. And as you heard the attorneys speak, the first one is being open and notorious. This means you don't want to keep it hidden. You don't want to come in the middle of the night come to the house in the middle of the night when everyone in the neighborhood is asleep and not know you're there, and then leave early in the morning before they wake up, so that they didn't know that you were there. You want to let them know that you are there. You don't want to hide it. The second one is it has to be actual and uninterrupted. If for any reason you leave town for a significant period of time, or you're arrested, incarcerated, or whatever, for whatever reason you decide to leave and not come back for quite some time, you've interrupted your possession of that property. Now, it also has to be exclusive, which means you're not going to share it with the homeowner. Okay. The fourth one is it has to be hostile and objectionable to the homeowner. That means they can't give you permission. Otherwise, it's not adverse. Adverse means that there's a conflict. Okay, it's against their wishes. If they allow you to stay there, then it is not adverse possession. So if you have a property and it is a rental property and it's vacant and you want to make sure that no one's there, and for example, let's say you come over one day and you do see someone there and you want to stymie the adverse possession, what you can do is give them permission to be there for a couple of weeks, and then at that point you require them to be out of the house. That interrupts their actual possession and control of the property, taking away the number 2, actual and uninterrupted. Okay? Now, I'm going to say this again. It is important that you establish that the property is abandoned, and here's one of the reasons. Criminal trespass is codified in RCW 9A 52070 and 080. Those are criminal trespass in the first and second degrees. 090 are defenses, built-in defenses to criminal trespass, and the number 1 defense to criminal trespass is abandonment. So therefore, if you make sure that the property is abandoned, you cannot be charged with criminal trespass. The other thing is, I got into this because some people around in different areas in different states actually were asking me for help because there's a little bit of trouble they had gotten into. And when I read their documents, I was amazed at some of the audacity that people had. Telling homeowners that they had taken their property and it was now theirs. They couldn't come back to the property unless they paid the mortgage. And then they would send a different letter to the bank saying that the bank couldn't foreclose on the property and for whatever reasons. There were various reasons that really didn't make any legal sense, but they did it anyway. And they could be charged, and in many cases they were charged with offering false instruments in the public record. Now, what I have listed here is Washington's rendition of filing false documents in the public record. So this didn't necessarily apply to them, but just about every county and every state has filing false documents in public record. They want to make sure that that stays above reproach. As you can see, it's codified in 2 different areas, RCW 40 and RCW 9A 60. Right. Now, there are pros and cons. There's a flip side to every story, right? So there are pros and cons in this situation. And actually, as you can see here, I started out with the cons. I'm typically a guy that likes to have my dessert first because I'm a fitness guy. But I'm going to throw the cons at you first because I want to leave you with a good taste. And that is, the cons are you're in someone else's property and your stay is dependent upon the homeowner record not returning. You're taking on someone else's problem left behind. And you have to think about that. As a real estate investor and agent, I saw a lot of properties that were dilapidated, that were uncared for, or not, I shouldn't say uncared for, but that were damaged because people would leave properties because they move out of properties that were being foreclosed upon, and the homeowners had to feel something about that. So they were probably upset. I don't know if they were upset and intentionally caused the damage, or they just were careless because they said, well, you know what, we're not selling the house, we're not getting anything from it, and so they just didn't care how things were taken out of the house. We saw drywall holes in the drywall. We saw cords or wires pulled out of the wall. We saw we saw floors that just were crazy, scratched up, carpets that, you know, where the dogs had been left or animals had been left in, and it was so just nasty that it took so long to clean the stuff up that they were just, you know, they were fixers, essentially, is what they were. Public perception appears to be negative towards adverse possession, so much so that some neighborhoods, some neighbors in certain neighborhoods have pushed the legislators in their particular states to either outlaw adverse possession in somehow, and it's really tough to outlaw it because, again, if someone has not claimed the property of the the homeowner of record has abandoned their property, then there's no one to injure. Now, the bank can come in and say, well, hey, they're injuring us. But then again, if they don't have the right to foreclose, then that questions that as well. So, but what some of these states have done is says, okay, well, fine. What we're going to do is say, okay, you may adversely possess the property, but what we're going to say is that you can't acquire title through that adverse possession. And there he goes. You may be able to live in the house, but you may not be able to acquire title in 10, 20 years. The pros are the home is occupied and maintained. It's no longer an eyesore for the community. The home being occupied means unsavory activities can be avoided, i.e. drug houses, unsavory people being in the property and maybe even casing your neighborhood. That actually has happened where people have taken up into an abandoned property and have taken that opportunity to case their neighborhood and actually rob them when the homeowners are not home. So those types of things do happen. And if you get to know your neighbors and let them know what's going on, they may not be so set against you being there. It does positively affect the local real estate market as well, i.e. supply and demand. If you take away some of the supply but the demand stays high, then the supply increases in value. All right. Now, that's a simplistic explanation of economics, but we all know the basic principles of economics: supply and demand drive prices. Now, here's the other thing that the Washington State Supreme Court was interesting with them when they refused to answer, is that it can keep properties with clouded titles off the real estate market. They said that MERS did not have the right to foreclose was not a lawful beneficiary of the deed of trust. And since it was not a lawful beneficiary of the deed of trust, it couldn't transfer the deed of trust. Within the deed of trust is the power of sale, which they use in order to foreclose on a property non-judicially. If they don't have that power and they do it anyway, that means that title is clouded. Now, how are those title companies ensuring those titles on those foreclosed properties that included MERS? This is why, one of the reasons why the Supreme Court refused to answer that question is because they didn't want to implicate these title companies in crimes or make their business difficult. All right. Now, the other thing is it keeps away animals seeking shelter. And I remember as a child, being an explorer, actually I went into a couple of abandoned houses, and it could have been dangerous, and I not known it. It could have been someone living in there that was dangerous. It could have been animals living in there that were dangerous. It could have been that the property itself was not safe. The floors could have been rotted or anything of that nature. Now, if you want to see other abandoned properties, not just real estate, but properties overall, real estate as well as other types of property that is here in Washington, simply go to that link that you see at the bottom of the page and scroll through the slides. See some interesting things there. Now, here's some other resources. And this, after we go through this page here, these links, I'm going to take you through how to research a property and determine whether or not it does involve MERS, and if it's something that you want, if it's a property that you actually want to include on the list to go out and check. All right. So there's stages to your research. You'll do research online, and then you'll actually go out to the properties and view them yourselves and check to see if they're vacant, and then establish whether or not they're abandoned. Now, the first two links are to King County sites. The first one is actually the King County parcel viewer, and there you can search by address, intersection, or by parcel number. And typically what we want is we want the parcel number, but there is also another reason that we go to that site, and that's to establish whether or not the property may have been occupied by the homeowner as their principal residence. And I'll take you through that to show you how to figure that out. The second link is King County Public Records, and this is where people record marriage licenses, land documents on land, things against title, things of that nature. You also see I have Pierce County here, so if you're in Washington in the Pierce County area and you're interested, this will be the link that you would use instead of the King County Public Records site. The fourth link you'll see is already familiar. You should be already familiar with because I provided it earlier. It's the link to research Washington State Supreme Court cases and appellate court case decisions. All right. The last two, Zillow and USA Foreclosure, you'll need accounts to those sites in order to use them. Those accounts are free to set up. All you need is an email, and they provide you information, or you'll be able to use them for your research. Now I'm going to take you to Zillow real quick, or take you through a property research. So here's Zillow. I'm already logged in, so it is Zillow and deals with, as you can see, a large section of the country, or excuse me, the entire United States, and may include Canada and Mexico. I'm not sure. I haven't used it for those, but I'm specific to Washington in this particular case. So I like to just search. I'm going to use an example and just search by zip code. And we're going to look at the Federal Way area out here as a suburb outside of Seattle. So when you, I'm sorry, let me show you something else. So I used Federal Way 9800003. One of the other things that you want to do is you want to click the parameters, or determine the parameters that you want to search by. You want to take out anything that's for sale. If it's for sale, then that means it's not abandoned, because someone is directing or intending, has an intention with that property, so it's not abandoned. So take out everything for sale, uncheck it. Also, you don't have to, but to make it more simple, I'm going to take out foreclosed properties, because if the bank didn't have the right to foreclose on it, you can challenge it, but you're going to be moving probably quicker than you would be if you're dealing with pre-foreclosures exclusively. I don't want the make me move, and I don't want for rent and recently sold. Now, the other thing to look at here, you'll see that in the information here area here over by the properties, by the thumb, you'll see that it says how many days it's been on Zillow. Now, since these properties are not for sale, Zillow lists properties that are either for sale or properties that are particularly that may be going under foreclosure, that have, where the homeowners have been served a notice of foreclosure. All right. In this case, it's only been on the on Zillow for 9 days, which most likely means that since when they give you, when they provide a notice of foreclosure, they give you a notice of 90 days out at least. That means there's at least 81 days before this house goes under foreclosure, which most likely means that the homeowner has not moved out yet if they just got it. So you can try, you can check it out. I'm just saying to make it easier, if you want to actually have a list of most likely properties that are vacant, get something that's been on there for a while, but you obviously don't want to one that's going to be in foreclosed next week. So let's say this one here that's been on for 51 days. Let's go to that one. All right, so they don't have a picture. They have a picture of the neighborhood, not of the specific house. But that's okay, because we're going to actually see that here in the county here in a second anyway. They pull all of this information down from the county. So these are the lot facts and the property facts and whatnot. Excuse me. This is a 10,000 square foot lot, built in 1968. Last sold May 2004, $325,000. Excuse me. Has a deck, has a basement, fireplace, garage attached. So that's all good information to know, because you like to know what type of property you're dealing with, if those are the things that you're looking for. Some people will balk at it being built in 1968. They want to try and get something newer. I always suggest that if you're going to do that, if you're going to get with newer houses and more expensive houses, you better be on with your research, because you have to understand that the newer the property, the more valuable they think it is, the lender sees it is. even if they know that they're not right in their with their documents or whatnot, they may push the issue, okay? Because you may be the only thing standing between them and that property, and making money off that property. And if the homeowner is not challenging them, they may see you as just a nuisance. So, and there's ways we can get past that, but we'll talk about that at another time. So we go down here to foreclosure information, and past that we go to foreclosure trustee or attorney information. Now here's what we do is go to this link here that says more foreclosure information and click on that. And what we're looking for is this parcel number that's right here. Now Zillow oftentimes does list this parcel number, but sometimes they don't. If they don't, you take the address and you take it over to King County Parcel Viewer. Like I just took I copied the parcel number. You can select to do it by address, parcel number, condo name if you have it. If it's a condo, I don't suggest doing those because they deal with the homeowners associations and whatnot. And condos are a little different anyway because you actually don't own the land, you only own the space between the walls. Or you can do it by intersection, so finding the intersection as I previously stated. What I'm going to do is copy or paste, the parcel number there, do a search. Oh, don't play with me. Alright, looks like King County's having a problem. Address not found. Oh, sorry, I did address. I didn't do, that's my fault. Bear with me for a second. Parcel number. All right. So this little window pops up with the information, a summary of the information on the house. Tells you the homeowner's name, his present use is a single family, it's in Federal Way, gives you the address. Now, if we did not have the parcel number, we would find it right here at the top of that window. Since we do have it, what we're going to do is remember I said we want to determine whether the homeowner actually lived in the property and consider that their principal homestead essentially. So we'll go to property report. We'll see a picture of the house here. Now, sometimes they'll have an updated picture. We don't know how long ago this picture was taken, so just because you see it here doesn't mean that that's what it looks like right now. That could have been taken 3 years ago. Could have been taken 5, 10 years ago. Anyway, typically I think they go through between every 5 to 7 years to try and update these pictures. So, but we want to click on the property tax bill because we're not necessarily interested in this page here yet. Once you get to this page, you're going to click the search. It says real property tax. That's what we're looking for. And we're looking to where they send the bill. Okay, that's what this is, the account or parcel summary. Here's the account number. The account is active, taxpayer's name, and mailing address. Now, this is important. The mailing address is the same as the house. That means that this is their primary resident. Okay, because this you're not going to have, if it's a vacant, or if it's a rental property, you're not going to send the tax bill to the renters unless you have that in the lease. Okay, so once we do that, then I'm going to go over here to, let's close this out. Then I'm going to go over here to the recorder's office, and in the recorder's office, you're going to have to go through a disclaimer. Now, I've been to this site several times. They haven't changed this disclaimer in a while, so I know what it says, but essentially what it is it tells you, one, that you can be monitored while you're on the site, while you're on their site for your activities. And then two is they don't want you to put in spy bots or any type of spiders, not spy bots, sorry, but any type of spiders or anything like that to collect information on a mass scale. They discourage that. They don't mind you using it for research because there are people that sit down at the in the office all day on many occasions to research property like I do sometimes. Anyway, you hit the accept. Once you read it and agree to it, you'll see that there's, again, you can look at marriage records, you can look at land records, but what we're interested in is official public records. Click search. Now, over here in the bottom left-hand corner, or near the bottom left-hand corner, you'll see that's where you can post the parcel number. Don't put a name in there, because if you put a name, what's going to happen is you're only going to pull up what happened with that particular property under that name. So if you only do the parcel number, you'll pull up all the information that is dealing with that property since they've actually provided this information online. Okay. Some of the things you will not be able to see here online. You'll actually have to go down to the county records in order to view the documents. For example, if you look at these deeds of trust, here there's 1, 2, 3, 4, 5, 6 of them. Yeah, 6 of them. You see none of them are posted here. And that's because you can't read. They don't want people reading them there. We were able to do that at one time, and I think people were abusing some of the information that they would get on there, and some homeowners are starting to balk at it and complain. And so they said, okay, well, fine. If people want to see the deed of trust, we can't stop them from seeing it, but they have to come down to the office to get it directly. Now, since there's so many deeds of trust, now another thing to note on this one is that there is a lien on the property, and it's from a homeowners association. What you want to understand is that if you decide to go after this property, you have to take care of the homeowners association just like the homeowners would, okay? Because they may have the ability to foreclose on you if you don't take care of them, all right? That's another question, because there's a question about homeowners association rights and so forth, and about contracts and all that, but we're not going to get into that now. So what I do is I go into the notice of trustee sale, because that's the important document that you want to see what is associated with this. And then we get into that deed of trust, and we see that this is the deed of trust that's associated with this notice of trustee sale. Click on that instrument number, and you'll see all of the documents that have been recorded in reference to that deed of trust. It's been assigned twice. The the trustee has been changed once, and the notice of trustee sale was, as you saw, was posted. I want to go to see the first assignment, because I want to know who assigned it, who had the deed of trust to assign it in the first place. Okay, so once I click on that link, I'm going to get the image here, and I'm going to click on the image. I pull it up as a PDF. You can pull it up as a TIFF if you please. It's more simple for me. All right. So then I pull up the document. You see that here it was recorded in 2011 by CoreLogic. All right. Actually, it was requested by Bank of America. But anyway, what's important is I want to see who transferred the property to whom. Now, in this case, we see that it was transferred to BAC Home Loan Servicing. That's Bank of America, a rendition of them. The original lender was Countrywide Bank, and Mortgage Electronic Registration Systems actually was the beneficiary of the deed of trust on this property. We've already established, according to Washington state law, and when you read those cases, you'll see that it specifically goes into what laws they violate, or what sections of law, I should say, they violate in their case. And so since we know that, let me give you an example. Does hereby, so MERS, for value received, the undersigned holder of the deed of trust, which was MERS, whose address is 3300, blah, 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 does hereby grant, sell, assign, transfer, and convey unto BAC, whose address is such and such, all beneficial interests under the certain deed of trust described below, together with the notes and obligations therein described. Now, that makes that particular statement right here, where it says together with the notes, MERS didn't have the note to transfer. So that is not true. That's a misrepresentation. That's how they say lie in legal terms. That is a misrepresentation of the truth. This can be considered a false or forged document, because if the unknowing public reads this and says, okay, well, MERS transferred the deed of trust and that the everything is valid, I'm going to go buy this house, and then come to find out that it actually didn't, and your title is clouded, you can not only sue them, but you can file a criminal complaint for them filing false and forged documents in public record. It's not necessarily forged, but it is false. Okay. So then what I'm going to do here is, once I establish that MERS is involved, I'm going to put it on the list, the ones that I want to go see, and I'll go to the, I won't actually go to the next one yet. Actually, I would, and then I would come gather all of my properties that I would want to go see, and I would bring them over to USA Foreclosure. And in USA Foreclosure, I've actually already started this, so let me go back. And I would put in the zip code. You can put in the zip code or the property address. Now, they really only like you to put in the street number for the property address. And it's weird because it's inconsistent. Sometimes they actually want the street number, sometimes they want the house number. I like to just put in the zip code and pull up everything that's going on in the area. All right. So one of the houses is in Auburn. I know it's not in Auburn. I'm not sure why I have to pick a zip code again, but I'm going to do it. I always leave the sale date blank because the dates can change, and I'll show you that here in a second. Now, you can do a search through this and find out if the property is listed here and when it's going to sell. It's not on this first page. Also not on the second, close, 28716, not 297. So it's not on the second page. And let's see, not on the third page either. So in this case, what I do, so what I do is I go back to the documents, the notice of trustee sale, and I would get the information of the trustee and contact them to see what's the status of the property, when is it supposed to go into foreclosure. They typically get these calls anyway because investors are interested in these foreclosures. They get notices that properties are going into foreclosure and they want to bid on them. All right. That's the purpose of them putting them up here, and that's the purpose of them attempting to sell them at auctions, because someone wants to buy them. And typically it's an investor. Sometimes it's a homeowner that wants a little bit of equity or to buy a good deal, or what they perceive to be a good deal. Now, one of the things to look at in this site is you'll see that it has the trustee number, it has the property address, it has the city, state, zip code, and status. Now, the statuses these are active, but you'll see they have different symbols for what they mean. And if you just put your cursor over them, you'll see that this is a hot property. What that means is that I guess they think that it's a deal that you really should go look at. It's most likely going to go to foreclosure, and so you should look at it to bid on it. All of these are active. I want to show you an example of something that is not active or canceled. All right, so you see this is where there's 1, 2, 3 canceled properties here. Now, if they had already gone into foreclosure, it would say what happened to it. Either reverted back to lender, it was sold to a third party. If it was sold to a third party, that means someone bid on it, made a successful bid at the auction. If it reverted to lender, that means they didn't get a high enough bid, and the lender wanted to take it back and was going to basically try and prepare it for sale. Send a contractor out there, whatever the case is, and attempt to sell it with a real estate agent. All right. Now, that's essentially how you do research for and establish whether a property is viable for being a target of adverse possession. Now, again, adverse possession is just one of the things that we teach people in our memberships, and obviously I've taught you how to do it here, and you're not necessarily a member. But to get into what the membership exchange of value is, or what it takes to become a member, here we go. We have a gold clause in our contracts where we essentially, we're not fans of Federal Reserve notes, but that doesn't mean we won't accept them. We just want to make sure that we cover ourselves, and we like to have, like I said, gold clauses. I know most people don't deal in gold, so most people won't have gold sitting there to be able to provide payment for it. So we will receive those payments in the form of notes, as long as we can transfer them to a form of tangible value. Now, the first number that you see is 7,000 or 5.5 ounces. That's if someone wants to pay up front and get it out the way and become a member. If they don't want to do that, or not willing to do that, because even if you have the $7,000, you may not want to part from it right away. You may want to do it out in payments as a payment plan. Then in that case, it's 6.25 ounces of gold, or $8,000, and it can be paid over a period of time, typically over a year or a year and a half, or even 2 years, depending on what your scenario is, and we're willing to work with people on that. That's not an issue. Now, some people are like, wow, that's expensive. Well, you have to understand what we're providing for our members. We're providing coaching, and we have to pay for all those things. We're providing life coaching, business coaching, education from other investment experts, business experts. We're also providing investment and business opportunities. This is not just a talk show, or a talk association. This is something where we actually put the rubber to the road and we get it going. We also have a social justice program that we're commencing to help homeless people and families that are in need, low-income families, and we obviously need to absorb those costs to be able to help them to do such things. So this is the essential cost of becoming a member, and if that's something that you want to discuss, feel free to contact me. I'll provide you the information there shortly, but do understand that your membership is not necessarily predicated on you doing adverse possession. You may or may not be interested in that. It just seems to be a hot topic of what people are interested in, so that's why I'm providing this video. Now, conclusion, remember, knowledge is power. That's the old adage, right? The old principle. Knowledge is power. So please remember to be safe and diligent. In no way do we promote the taking of anyone's property or criminal trespassing. Make sure that any property that you target is actually abandoned and not just vacant. Also, the information in this presentation is specifically for Washington State only. Okay? And because adverse possession is so misunderstood and unpopular, in some cases due to abuses, make sure that you check the law of your state in order to determine what course, if any, you should take. We can help you with that research as well. Again, I have done work in other states. I prefer to stay and deal with Washington, but again, I know I will be branching out to areas like Illinois because I like that program that they have to establish something for a residence for low-income families. And lastly, know that the common difference between squatting and adverse possession is essentially your intent with the property. Are you exclusive possession for your home, or are you using it as a property to lay your head? That's very important in understanding is, are you squatting on the property in order to just find shelter, temporary shelter, or are you attempting to take control of the property and treat it as your own or treat it as the homeowner would? And if that's the case, you have to treat that property just like the homeowner would. You would do everything to it. You would pay taxes, legitimate, legal, lawful taxes, lawfully assessed taxes. You would cut the yard. You would pressure wash the house. Take care of the roof. All those situations you would. You have to understand that you will not be able to mortgage the property, and you will not be able to sell the property until you actually get title into your name, and that requires time. And really, in Washington, you have 7 years where you can actually pay the taxes, and you can attempt to go and acquire the property or acquire title to the property. You may or may not get it, but after 10 years, everybody has a statute of limitations, and unfortunately for homeowners, if they haven't been monitoring their properties for 10 years, they probably are not coming back at all. But if they haven't, and you've recorded something in public record to establish when you commenced your possession, and it's 10 years later, statutes of limitations doesn't allow them to come and recover that real property. Right? Now, here's the information to contact me. If you have any questions that you want to ask, you can reach me by email and reach me by phone. I can tell you this, is that if you want to reach me by phone, sometimes it's pretty tough because my schedule is pretty busy, but I am available on Skype, and it is easier for me to respond via Skype and or a text than it is to talk, because in many cases, literally, my conversations with people, because of the questions, end up being an hour long. And I can't do that all day. And sometimes even longer than that, where I have to actually cut it off short. So if you want to look me up on Skype, here's my Skype name, Nas ***, or the name Kuwa. You can look me up by this address as well. Anyway, I definitely appreciate your time in viewing this, and I hope it's been enlightening for you. Thank you so much, and live strong and be well.